Hello, good afternoon, and welcome to The Law. This is your legal light. It is your health law. And this afternoon, asking a question that some of you have been asking. Are you asking from an informed position or just because you don't have information about this new regime? It's a law that is called Plea Bargain. What is it? Is it exactly justice on sale or law for the rich? That people get to commit crimes, they get to plead guilty but never go to jail? I'm Samson Lardy Anyenini. We'll be right back.
71 subsection 1 of Office of Special Prosecutor Act 2017, Act 959. Plea bargaining. A person under investigation or charged with corruption or a corruption-related offense may voluntarily A. admit the offense and make an offer of restitution, or B. admit the offense and offer to provide information that will aid in the arrest and prosecution of other persons whom that person knows have committed or are about to commit corruption or a corruption-related offense. Section
You're welcome back. This is The Law. It's your legal light. It's your health law. And we are discussing the topic plea bargain. Justice on sale? That's a question. And that's deliberate because there is a certain perception out there. But is it correct? That is what we are going to get some education on. And we are privileged to have the Deputy Attorney General and Deputy Minister for Justice, Dinah Asonaba Dapaah, join us. Thank you so very much for making time to join us this afternoon.
Thank you, Sam, for having me.
Great. Right, so we normally start the show with what we call the Law 101. And today on the Law 101, even though we are looking at this new law, which is an amendment to the Criminal Offences Act, we want to focus on Section 71, subsection 1 of the Office of Special Prosecutor Act 2017. What will be your explanation to this particular law?
Right, with respect to Section 71,
That is right.
I think you will know that what we're discussing is the Criminal and Other Offences Procedure Amendment Act. It's an amendment to Act 30. Now, it covers in broad terms what plea bargaining, considering that Ghana had earlier had stints with some plea bargaining provisions. Even look at the Courts Act, Act 459. And so this provision, as you've directed, Section 71, is only a part, or it's a provision that underscores plea bargaining, which we've had in other legislations.
It says a person under investigation or charged with corruption or a corruption-related offense may voluntarily admit the offense and make an offer of restitution, admit the offense, and offer to provide information that will aid in the arrest and prosecution of other persons whom that person knows have committed or are about to commit corruption or corruption-related offense. What does it mean? If I have been caught, so to speak.
This provision, as you've rightly identified, is a plea bargaining provision. Okay. And perhaps if you can start with what a plea bargaining is, it's a process within the criminal justice delivery system where a person charged with an offense relinquishes his or her right to go through full trial in exchange for some other benefit. Now, the benefit may come in three forms: that either you have the charge against you reduced to a lesser charge, or that the charge is withdrawn totally, or that the punishment for the offense for which you're being charged is reduced. Now, this is just one bit of the plea bargaining provision that we have in our laws in Ghana. And so with this provision, if you're being charged or investigated for a corruption-related offense, you may agree, or you may plea negotiate and arrive at an agreement with the prosecutor to admit the offense and make an offer of restitution, which is one way by which the plea agreement can be reached, or that in exchange for going through the full trial and you being convicted of the offense of corruption, you would admit the offense and rather help to, as it were, grab other persons who are also guilty of the same offense of corruption.
In other words, you're using one suspect or accused person as a bait to get more.
Correct.
So the benefit they get is to identify others and then they don't suffer.
No, they do suffer.
Okay.
And that's the perception we need to take out there. You will still plead guilty.
Right.
You are convicted for an offense.
Okay.
It may be for a lesser charge, but you're not acquitted, for lack of a better word. You're not acquitted of the offense. Okay. You are still charged for the offense. In fact, if you look at the Act 1079, it requires that you admit to the agreement, the offense that you have agreed to, which is whether the lesser offense, and then based on the guilt plea, the benefits come. So based on the guilt plea, then you offer to do restitution, or that you are charged for a lesser offense. So there's nothing like you go scot-free. You are convicted on a plea of one of the offenses, or even the offense itself, but instead of going through a full trial or being charged within the range or maximum of the punishment for the offense, you do a restitution, or you help the prosecution to charge other persons. Yeah.
All right, so if you're just joining us, as we always do, this is the Law 101 segment on the Law Show. And our aim is that if by the end of this program you forgot everything, you shouldn't forget this particular education. I know that this afternoon there are many lawyers who are tuned in, particularly because we are discussing a very new law. Many have not even seen the law yet. They don't know how exactly it looks like or feels like, but are likely to want to use it for the benefits of their clients. And you too may want to pay attention, so that in case you come into conflict with the law, so to speak, criminal law, you may see if you can take advantage of that law. And we have in the studio Dinah Asonaba Dapaah. She's a Deputy Attorney General and Deputy Minister for Justice. Now, take us through, first of all, why the government felt the need, or more specifically speaking, your ministry and agency felt the need to push for such an amendment to our laws.
Thank you, Sam. This change in the law is one of many reforms being undertaken by the Office of the Attorney General, specifically by the Honorable Attorney General, Honorable Godfred Yeboah-Dame. You also know about the legislation we're pushing on the community sentencing. That's right. Now, the whole idea of plea bargaining is to achieve mainly three things. Is to avoid the protracted trials, delaying trials, and thereby ease off the congestion that we have in the court. One of the main goals of plea bargaining as well is to decongest the prisons, because of course, if persons can plea negotiate and reach an agreement whereby they are given a lesser punishment based on the lesser charge that they've pled guilty to, then it will reduce the prison sentences that we have. But more importantly, and for me as an ADR person, was also the aim of plea bargaining, which is to ensure restorative justice. Okay. Now, plea bargaining ensures that a very critical stakeholder of the criminal justice delivery system, which is the victim or the complainant, sometimes the victim may be dead or may be nowhere for the victim or the complainant also get justice. And for me, that is a key issue. There are also other benefits of plea bargaining. And so it's a reformative step within the criminal justice delivery system.
So when you talk about restorative justice, you're talking about circumstances where our criminal law largely seeks to punish the offender, and then the victim is left without any compensation, without any sort of so to speak. Yes. That's what you mean.
Yes. So restorative justice basically includes the victim in the whole process of the criminal justice delivery system. You know that in Ghana, when you commit a criminal offense, it is deemed to be an offense committed against the state.
That's right.
In the past, the interest or the interest of the victim was disregarded, if I can say it that way. Now, plea bargain, if you look at our provision, it enables the victim or the complainant or their representatives to make an input into the plea agreement that is negotiated between the prosecutor and the accused person, to the extent that the victim may even make representations to object to the terms of the plea agreement, and to the extent that the prosecutor shall not conclude a plea agreement without the involvement of the victim or the complainant.
Okay.
And further, the court who supervises or superintends the whole plea agreement before enforcement is also charged to ensure, to invite, and in fact receive representations from the victim or complainant. And one of the results, the outcome of plea bargaining, is that the accused person may agree to pay compensation to the victim or to make restitution. Right. And so we realize that, unlike previously, the victim plays a very crucial role in the whole criminal justice delivery system. And for me, that is a good thing.
Great.
To be proud.
Right. So in due course, as we always do, we'll open the phone lines for you to join us. Your understanding is that the plea bargain regime is a regime that is intended to benefit the rich. You are getting some explanation by now. How the victim comes into the picture, unlike formerly where the victim was just left unattended, so to speak. You have a certain perception that plea bargain is justice on sale. The rich can steal, can commit crime, and pay to go free. She began by explaining that the first thing is that you will have to admit to your guilt. You admit to the offense, and then you will be convicted. It is jail that you don't go, but you get convicted.
Not go.
You may not?
You may not.
Please explain that.
Good. So one of the benefits that you may get is that in exchange for going through the full trial and being sentenced to prison, you will assist the prosecution to get other offenders. But you see, Sam, there are a number of considerations that go into this particular type of benefit. You look at persons who are, as we like to call it in our term, the little fish. Take, for instance, a courier in a drug chain supply.
Okay.
You'd realize that he may be arrested with a drug. Of course, ignorance is no excuse. Yeah. May be charged with the possession, but may not even have an idea what is contained. We've had experiences.
He's only just the one being asked to carry the drug.
Very well. So
the kingpins are there.
The kingpins.
So you use that person.
So we use that person to get the kingpins. So in saying that you may not be sentenced to prison, it is not for all offenses, for lack of a better word. There's deep consideration that goes into the whole process of plea negotiation, with the judge also playing a very important role in this, which, given the opportunity, I'll go into it.
So very soon we will dive deeper to ask the question, does this cover all offenses or all crimes?
Right.
Is that what it is? But just that bit that you started explaining, does it mean that someone can take advantage of the plea bargain regime, and instead of getting, say, an offense that could take the person to prison for about 25 years, then they will get a lesser one? So in the end, they will be put to jail, but for a short period.
And the minimum range of the prison terms.
Okay.
That's something I'm very interested in, the perception that this plea bargain is for the rich, and it's a bit.
It's for the rich, or that it is justice on sale?
Oh, it's justice on sale. And I'm unable to agree with that assertion, because there's no basis, whether legally or empirically. Now, if you look at Act 1079, it says that the accused person, the accused person or the prosecutor may initiate the plea negotiation.
Okay.
And there are no economic status considerations in the commencement of the plea negotiation. The law does not say that you have to be of a particular economic status before you can invoke this plea bargaining provision. And of course, there is a whole chain of people involved, including the victim, which I've mentioned,
right,
who may object to the terms of the plea agreement, and the court is obliged to invite and consider the objection of the victim. And again, it is not just between the prosecutor and the accused person to conclude the agreement and enforcing. The court may also decide to reject the plea agreement. And so again, empirically, I say that I find no basis for that assertion that plea bargaining is for the rich.
I think some of what is
on sale.
informing that kind of assertion is that recently there are some big cases that your department is doing involving the bank collapse issues and the financial institutions that have collapsed. And we have been hearing that some of them are making, certain requests. Of course, we know of one that has gotten something like this and is making a payment so that it doesn't go through a trial. Just a week or two ago, and in America, as we speak, one of the Donald Trump, his organization's chief finance officer has pleaded guilty to 15 felonies. And the organization, we understand, if it is found guilty, they could pay back taxes and fines, but no one else would go to prison. And this particular individual has been with that organization for over 40 years, and he's been able to cut this deal. The deal is that he's going to testify against the organization for the tax fraud that they've been involved in, or all of those things. And he's going to pay some $2 million. In exchange, he gets only 5 months sentence in jail. He will not implicate Trump in the trial. So people see this and say, yeah, that's justice on sale. Because he has money, he's going to pay this much, and then he goes for 5 months when many felonies involved.
Right, Sam. I mean, you in citing the facts to me, I could not help but realize the inherent benefit in what has been planned or what has been negotiated by way of plea bargaining. Sam, criminal trials are expensive, particularly for a country like Ghana. And sometimes you know that if this person should serve the full sentence, the monies will not come back to the state. I mean, exposing the persons behind the fraudulent scheme and etc. will not be brought to fore. Yeah. And so you realize that the benefits of one, taking the monies back to the state, the benefit of putting an end to whatever scheme by reason of the fact that he's going to help the prosecution to unveil all those schemes. For me, weighed against going to prison and keeping all those monies back, for me, I think quite debatably, it's more beneficial with this plea bargain.
So let's go in now. Who may, get a plea bargain into the Attorney General or the prosecutor, and what are the offences for which one may be allowed to plead to take advantage of plea bargaining?
Right.
You are still here on The Law. This is your legal light. It is your help law.
Thank you, Sam. I would say that the new law on plea bargaining, which is the law that amends Act 30, which is the Act 1079, all offences can be plea bargained except those offences that have been listed under Section 162R. And these are high treason or treason, high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking in an offense related to public elections. So aside these offenses, all offenses can be the subject matter of plea negotiation to end in a plea agreement.
These are the most serious offenses. Why do you exempt them? Take us through the list again, and then let's see.
So we have high treason or treason, We have high crime, and I'm reading from section 162 for the benefit of your viewers. We have rape, we have defilement, we have genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and any offense related to public elections.
So, for example, why the sexual offenses, rape, defilement? Because we know that in the villages or even in some of the towns, people get to pay their way through some of these things.
Which is illegal to start with. And in fact, something, a lot went into this plea bargaining law. Now, we did a number of comparative studies. You will find that some states had exceptions to the plea bargaining laws. Some states did not have exceptions at all. Okay. But whether a state has exceptions or not is always backed by public policy considerations. Now, we had a whole debate, deep debate about these exceptions. Some were of the opinion, but the stakeholder engagement that we had as through the working group that worked on this bill before it became law, what we picked from the public is that there was so much repugnance. They felt these offenses for them are so offensive and they abhor these offenses. And so they could not fathom. Exactly.
If you are caught in rape or defilement, you should not be forgiving at all.
The public felt that these offenses should not be subject to plea bargaining. And so that's what the stakeholder. Now, if you do a comparative study, you find out that even in India, you may plea bargain all offenses, except, the sentence for the offense must be 7 years or less. Beyond that, you cannot plea negotiate to arrive at a plea agreement on any offense. If you look at Kenya, they looked at violent crimes, sexual violent crimes against women and girls. This is how they put it. They look at genocide. Their history determined for them why they abhor certain offenses, and so those offenses should not be subjected to plea bargaining. If you look at the state of California, you'll be shocked that you cannot plea bargaining offenses that what we call driving under the influence of alcohol.
Really?
In our jurisdiction, you may think that is a minor offense that should be
because that's a misdemeanor
to
somewhat.
Exactly, but it was rampant. The history indicates that at a particular point in time, people were dying a lot, and so for them to show how much they detest that people are continue to engage in driving under influence, they decide that it should be exempted from plea bargaining. If you look at Nigeria, there are no exceptions. The only caveat is that one, there should be restitution to the
victim,
to the state, and that the offenses should be such that you cannot get a cogent evidence to charge the accused person. So it depends on the state. And for us, the stakeholder consultation we had indicated that Ghanaians felt that for these sexual offenses, for these offenses like murder, you cannot and should not subject it to plea bargaining. But with high crime and treason, the act itself indicates that those offenses for which the punishment is death cannot be the subject of plea bargaining. And the Constitution even indicates the punishment, the death penalty for some of these offenses. Our criminal procedure indicates that you cannot even plead guilty for an offense for which the punishment is death penalty. And so those were given. That's why they were abducted. But I believe Ghanaians feel that rape, abduction, etc. should not be the subject. And we listened to Ghanaians, and that's what we came up with.
All right, at the right time you will join us, but what is this? That we are very religious, incurably religious, and yet we can identify certain sins or offenses and say, for these ones, thou shalt not forgive. This is the law. It is your legal light. It is your help law. And we are getting education from Dinah Asonaba Dapaah, who is a Deputy Attorney General and Deputy Minister for Justice. In due course, we'll open the phone lines for you to join us. I hope that some of your impressions that you have about this particular regime are being dealt with. Now, how do I first of all avail myself of this, plea bargain? How do I get to do it? If I am arrested that I have committed a particular offense, how do I go about accessing this and say, okay, look, I know this one day I'm guilty. I'm coming to tell you I'm guilty. And then maybe I pay or make restitution and so on, and then you get me convicted, but I don't want to go to jail, that's all.
Right. So if you look at section 162 of the Act, the Plea Bargaining Act, it tells us that any person charged with a criminal offense before judgment may negotiate with the Attorney General for a plea agreement. And so you ask the question, who can initiate plea negotiation? Is either the accused person or his or her counsel or the prosecutor. And so when you're arrested and charged with offense, again, don't forget, and I think maybe I should make that point out clear, with the Republic versus Eugene Bafuboni and 4 other cases, where there's now extensive disclosure as a mandatory requirement to criminal justice. Now, the accused persons usually will now be faced with imminent evidence against them. And so when they are usually faced with this disclosure to know the evidence that's going to be used by the prosecution against them, you can write to the Attorney General, the prosecutor, and make that intimation that you would like them to plea negotiate. So the law allows, it is not just the prosecutor who can initiate plea negotiation. The accused person or his or her counsel can also initiate it. And by law, once this intimation comes from the accused person and the prosecutor agrees, don't forget, the prosecution too are happy to plea negotiate because it saves everybody time. Because we have to now go through the trial of adducing all these evidence, which is glaring at the disclosure stage of the criminal justice.
So what she's referring to as disclosure for unlearned minds is that you, the one who's been arrested or accused and about to be charged, has been charged with a particular offense, the evidence that is going to be used against you, the documents and, you know, those things are given to you. So you get to see what it is that the prosecution is going to use in court against you. On the basis of that, you are able to make an informed decision that the thing have been caught. Even if I try, I will lose. And sometimes you can now see that if you wasted everybody's time to the end, then you could suffer the ultimate punishment. And that may not be good to you. So that's what she's saying. That helps. So you, together with your lawyer, will make a decision whether you should write through the prosecutor or to the Attorney General and say, look, we beg, can you help us out? All right. Can
we shorten this? We all know that the inevitable will happen. Can we shorten this? And can I make some of it? So once this is done and the prosecutor agrees with the accused person, the prosecutor or both the prosecutor is mandated to inform the court of this intimation from the accused person. And then the court adjourns the matter for 30 days to enable both parties to plea negotiate. Of course, it's after 30 days, if the court so desires, they may extend the period for negotiation.
Plea negotiate? What are they negotiating?
So they are negotiating.
I am guilty. I just say, I'm begging you, let me...
Okay, so that's what I talked about, the benefits. I am guilty, but do not sentence me to prison, and I will help you to get the other persons involved in the crime.
Okay.
I am guilty. Now, I will not waste the prosecution's time to go through a full trial.
So that take us years.
In consideration of that, you give me the minimum sentence or the mid within the range, but not the maximum sentence.
Okay.
Or I am guilty and I'm willing to make restitution for those financial related offenses or corruption cases. I'm guilty, but I'm willing to make restitution. So it's guilty with some conditions. Either, and the benefit is what I talked about, either that I'll be charged with a lesser offense. So if I'm going to be charged with stealing, I will plead guilty, but if I could be charged with dishonestly receiving.
Okay.
So you be charged with a lesser offense instead of the greater offense.
Okay.
Yes.
And it's a negotiation, you call it a negotiation.
We call it the plea negotiation.
Because the Attorney General, more importantly, must agree.
Yes, so it's a negotiation between the two parties. So there must be an offer and there must be an acceptance. So it's either there is usually negotiation, a bargaining back and forth until the two parties, which is the prosecution and the accused person, arrive at a mutually what I call a mutually beneficial agreement.
it is possible that you will not agree in the end.
It is very
within
possible.
the 30 days.
It is very possible. And again, best practices or comparative study of other jurisdictions will determine that usually plea agreements are reached between the prosecution and accused persons, usually for instance, young offenders, first-time offenders. And so you cannot be what we call, you cannot be a notorious offender in law. The hurdle then becomes higher.
Okay.
Why we should let you off the hook this time by giving you a lesser charge or giving you the minimum sentence when you are known to be committing those offenses. So there are a number of considerations. In fact, if you look at the law, it says that plea agreement will be concluded after the prosecution has considered many factors, including the interest of justice, including the previous offenses committed by the accused person. And so, yes, there can be a rejection of the offer from the accused person in the plea negotiation process, yes.
Right. So if it's a financial offense, for example, the person, what they are being prosecuted for is $1 million. Is it the case that you'll be asking them to pay more than $1 million, and that's why they may not agree to that condition?
No, come again.
If it's a financial offense and they are supposed to pay back money.
Yes.
You are taking them on, they will face jail, but this is the money involved. So if you meet with them and you are negotiating, you'd want them to pay the money back.
The 1 million back, yes.
Exactly. Is it the case that in such situations, your condition is that you not just demand the 1 million, but more, and they may not be able to afford that?
We could, and if they may or they are unable to afford that, that means that the offer has been rejected.
Okay.
And so we proceed with trial, yes.
Right. So we are discussing plea bargain. Is it justice on sale? I believe that by now you are beginning to get a better appreciation of what this is. And like she explained earlier, there have been some little bits of it available in our law, but this is the first time that we have decided to do a comprehensive sort of review of the law and provide an extensive regime where people who come into, if you like, conflict with the criminal law have the opportunity to do a plea bargain. Now, shall we know that you mentioned earlier, maybe the judge, first the victim, you focus on the victim,
Right.
also the judge. What role do they play in all of this?
Right. So if you look at section 162G,
Okay.
it talks about consideration of plea agreements by the court. First of all, at the point of plea negotiation, the judge plays a role. It says that the judge may adjourn it for 30 days. The whole idea of adjournment is so that the court closely monitors the plea negotiation, so it is not used as a tool to hold the criminal prosecution on hold indefinitely. Now, the judge is mandated to proceed with trial if the judge realizes that the plea negotiation is taking unduly long. So at the point of plea negotiation, the judge plays a crucial role, which is that I am giving you 30 days to go ahead and plea negotiate and come back to me to report if and whether you have reached some form of agreement. Of course, if they come back after 30 days and they have not concluded the negotiation, the court may grant them further extension. But again, just like we have in court, the adjournments are at the discretion of the court. If the court realizes that it's being unduly delayed, the court may decide to proceed with trial. But then the Act still says that notwithstanding that the court proceeds with trial, in the background, the parties may still negotiate. Of course, up until the time of judgment, if they have perhaps reached some form of agreement, the court may consider it. Now, where the parties conclude or come up with a plea agreement, now they file it within 7 days. The law mandates them to file it in court within 7 days. Now, at the point of filing, the court now looks at the plea agreement, considers it, and then invites representations from the victim or the complainant. And so that's why the court serve as a guard. They guard the whole process. So it's not just between what the prosecution and the accused person have decided. The court can reject the plea agreement. The court invite these representations from the victim and shall consider them. Of course, if the victim finds that there's been a collusion of a sort, the victim is at liberty to bring that to the attention of the court, and the court shall consider same. And so the final decision, if I should say, now rests with the judge to say that, and if the judge rejects the plea agreement, she's mandated to give reasons for the rejection. Again, even if the judge rejects the plea agreement, it doesn't stop both the prosecution and accused to negotiate on another term.
Okay.
Perhaps if it was the lesser charge that they were charged, the judge found that, look, the facts do not support the plea agreement, you may reject it. And then you can come back to the judge. So the judge then guards the process pre-plea agreement, which is the plea negotiation stage, guards it at the conclusion of the plea agreement for the parties. So if you realize that then there's a stakeholder involved to the extent that if the judge finds that the victim is able to expose certain undue happenings in the process, the judge is mandated to consider before accepting the terms of the plea agreement.
I thought that the judge was playing only a nominal role in a plea bargain process. All the judge was to do is to wait for the accused person and the Attorney General of the prosecution to come and say, here is the plea agreement. And the judge will simply endorse it. I didn't think that the judge should have a role in rejecting the plea.
Right, Samson, if you look at section 162H, we are told that the judge shall not accept a plea agreement unless the court is satisfied that the person, for instance, was of sound mind. And we all know the terms of mental incapacity in the whole criminal justice system, or that the accused person entered into it and signed the plea agreement involuntarily.
Okay.
So these are the things that the court must.
So it appears to be rather a protection for the accused person.
It is a protection for the accused person. It is not a discretion that ought to be exercised unreasonably, but it is a protection for the plea bargaining process itself. And it is a protection even for the accused person. Because section 162C requires the prosecutor to consider certain things before he initiates the plea negotiation with the accused. That first, he must tell the accused person of his rights.
Right.
That you have a right to full trial, you have a right not to admit guilt, you have a right not to say anything incriminating against you, you have a right to counsel. And so if it appears such mandatory requirements are not fulfilled by the prosecution, the court is mandated to reject the plea agreement.
Okay.
In that case, there's not been it's not the process has then not been fairly undertaken. Yes.
Okay. And you had mentioned earlier also that the prosecution can initiate the plea
as well as the
process.
accused person. Yes.
So I am going to prosecute you, but on the basis of the evidence I'm looking at, I feel, look, you'll be wasting my time if we go through the trial. So I invite you and inform you that I can give you a lesser charge, or I can let you do this, do restitution, and then this is what you get. Prosecution can do that. All right. So this is the law. It's your health law. It's your legal light. We open the phone lines now. Join us. If you have any questions for Madam Diana Asonaba Dapaah, a Deputy Attorney General and Deputy Minister for Justice, she has been explaining the plea bargain regime to us. It's a very fresh law, let's say the latest among the laws that the Republic of Ghana's Parliament has endorsed from the Attorney General's Department, and also has been assented to conclude, as it were, an amendment of our laws. Gives opportunity in the manner that has been discussed. So please join us. You know the phone lines, they are on your screen right about now. Call us and ask your questions, and if there's anything on your mind about this. let us also know. Now, you talk about the whole thing becoming sort of an agreement that we have reached. Supposing I don't follow the terms of the agreement, what happens to me?
The agreement stands vacated. And so
I've already been left to go. I have not been put into jail.
Again, sometimes I told you, those will be sparingly used. Usually, by practice and comparative study, you get sentenced for the lesser offense. I don't want the impression to be created that it's almost a given that you'll be let off the hook. And I've told you a lot of considerations go into the young offenders, first-time offenders, right, the nature of the offense, etc. And so if the plea agreement there's a breach of the terms of the plea agreement, it means that the agreement stands vacated. Now, if you look at the templates, how these plea agreements are coming, there's always a provision that says that if I should breach the terms of this plea agreement, the agreement stands vacated, and then trial will continue from where it ended at the point where the plea agreement was
So if we're to pay
reached
some money, and you are giving a certain period to pay it, and you are defaulting without good reason, then you are breaching the agreement. If you had agreed that you lead the prosecution to some other people who are into the crime, and then subsequently, after you have been taken through the process and you were convicted and perhaps sentenced to a minor, a lesser offense, so to speak,
or the minimum,
having been left to go, which you're not too
we'll
keen
rearrest
on.
you, and then the trial proceeds from where it ended.
You start all over again.
Yes,
fresh.
we'll start all over again because it was a term of the agreement that...
Oh, yesterday you left me, then today because I didn't...
Because you breached the terms of the plea agreement. And so the trial will proceed, just like when it is rejected even by the court. If the court rejects a plea agreement, then the trial continues from where it ended.
Okay.
If you breach the terms of the plea agreement, the agreement stands vacated,
we'll
and then we will
bring
proceed with the trial. That's correct.
Justice, you're calling us from Chifu Praso. Let's hear you. Hello, Justice. Michael, you're calling from Osu. Yes, Justice,
so
let's hear you.
I want to know whether there's a difference between murder and then stealing.
You want to?
I want to know, when she was talking about the exemption, she talked about murder. So I want to know whether there's a difference between murder and then stealing, robbery and stealing. Yeah.
Okay, so, clearly, murder is exempt from plea bargain regime, and robbery is also exempt. You want to know the difference between murder and robbery?
Then the stealing, what about stealing?
What about killing?
No, stealing. Stealing is not exempt.
It says killing, not stealing.
Oh, killing.
I don't know what you are getting. Stealing. Oh, the difference between stealing and robbery.
Yes.
Okay, thank you. Michael, you are calling from Osu. Let's hear you.
Yeah, good afternoon, Samson.
Good afternoon.
My question is related to the offenses that, when successful with the plea bargaining, will lead to restitution of whatever that was stolen or something like that.
The list of offenses for which you can benefit from plea bargaining.
No, I'm not saying the list. I'm saying it's related to those offenses that, if it's successful, will lead to the restitution of the money stolen, like corruption.
Okay. Do you understand his question?
No, I don't.
Okay. So for those ones, how does, so I know I have the money. If I am caught and then I see that I'll be guilty of the offense, I'll make the offer to make restitution. So in that case, I'll be emboldened to do it. So when I'm caught, I'll do this. So what is there in the law to disincentivize people from committing such offenses so that they wouldn't have to do it in the first place? Is my question.
Right.
All right.
I understand.
Ellie, you are calling from who? Let's hear you. Hello, Ellie. Okay, Ellie, you have to call back. So you can start with Michael.
Right, so Michael is on the disincentive.
Yes.
Right, so Michael, in response to that, I would say that you get convicted, you're a convict, even with the restitution. And that's what I want people to understand. You are not acquitted of the offense. Your records will indicate then that you are a convict. And of course, for persons who are in various services, you know what a conviction on your record can disable you from, doing so many things. And again, it is not a given that even with those offenses, you will be asked to make those restitution, and then you be convicted, and that will be the end of the case. There's a holistic view to the whole process. And I've told you that if you are notorious, if you are notorious for committing those offenses,
it's up to you to accept or not to accept.
Exactly.
Okay.
So,
right.
Yes.
I was going to say that there's a case that I'm in and doing, and I discovered that my clients, it wasn't the best. So we could use the Section 35
of the Courts Act,
which also says that, we
can make that offer.
Reparation and restitution. So we approached the Attorney General. The Attorney General agreed that they should pay, it was money matters, that they had stolen some amount of money. Right. So they agreed and said, we'll pay the money back. Attorney General says, you pay the money and pay interest on it. Then we went to court, they pleaded guilty, they were convicted, but they were not sentenced. And then they were given a period and they paid the money. So they are ex-convicts.
Yes.
Except that they didn't go to jail.
And they've paid the money with interest.
With interest.
To the state.
That's right.
And of course, if they had not paid, immediately they'll be sentenced.
All right.
Upon breach.
We'll go to the justice's question. Says he doesn't...
The robbery
and stealing.
The stealing is a crime against property, while robbery is stealing but adds force or also adds intimidation or force to the person whose property has been stolen. And I guess the difference here is in the force that is used in robbery. So not just taking the property or depriving the person of its property, but beyond that also the force that is used against the owner of that property.
Zachariah, you're calling from Akumadan.
Counsel?
Yes.
Please, I would like to know whether if a plea is entered, then suspect is let go, and then later it is realized that the particular suspect is let go. Is the prime, is the actual cause of that particular crime, but then plea is already entered and the person is left off.
Yes, you are talking from the assumption that it is only the example she gave. That's not the case. You can be the main person behind the offense and still be amenable to enjoy the plea bargain. Frank, you're calling from Dunka Onofing.
Yes, please. Hello?
Frank, let's hear you.
Please, I want to know if someone is found of committing offenses and that offense that the person has committed is his third time, can he be bargaining on the plea bargaining?
Okay. You've been listening. You've been listening all along. Frank, you've been listening all along.
But it's found of making offenses.
Okay, it's all right. We'll repeat that for you.
I think the prosecution will be quite disinclined to, negotiate with you to a plea agreement when you're a third-time offender, particularly of the same offense.
Okay.
So what were the lessons that were not logged in the first time you committed the offense? As a prosecutor, these are very hard questions that I will be asking myself, that why should I give you this benefit for the third time? And so that becomes a higher hurdle for the accused person to convince.
But you want to clear most of your cases
we
quickly,
do, but
and then you don't want to spend too much and waste many years.
But there's this also the aspect of the deterrence. I've told you that restorative justice is key to the whole plea bargaining regime, but also, if you look at all the principles on criminology, there are various reasons for punishment. Deterrence is part of it, but at this point, it does not take the front row in the criminal justice delivery system, but it doesn't mean that it is totally done away with. And for me, a third-time offender as a prosecutor, I'll be quite slow or disinclined to enter into a plea agreement with such a person.
What do you say to those who say that a plea bargain regime emboldens impunity because somebody feels it's highly probable that I can pay my way?
Right. First of all, Samson, it's not a given that the prosecutor may agree with you. You know, there are so many things that the prosecutor even takes into consideration. Remorse, your willingness to even, as it were, compensate the victim, to appreciate. So there is some humanity to this whole plea bargaining regime, and that is what we look at. And so, first of all, I'm unable to disagree with the assertion that it would encourage impunity, because what makes you think that the prosecution will agree with you in the first place at the point of committing the offense? And in fact, if it comes to our knowledge, if you're saying that it will encourage impunity, that means that you and I know that it is impunity. It's we are going to encourage impunity. And for me, it's one of the considerations as a prosecutor to agree or not to agree.
Is it your expectation that after this law has now come into operation, you're going to see a lot more people and lawyers trying to use it?
I believe so. And so the Office of the Attorney General, we've put together a working group to help with the implementation. Of course, one of the things we realized that we need to do considerable education of the public, and I'm happy that you've taken the lead on this topic.
We thank you for agreeing to do this.
Thank you. I know it took you quite a while, but to educate the public especially, and so to let them know that you have that right to commence the plea negotiation. It is not only the rich, because the law does not preclude the poor, for lack, if I should put it that way, from initiating plea bargain. We need to educate even investigators. We need to educate the general public, for the general public to know that if I become a victim, if I become a victim, or I'm a complainant or related to a victim, I have the right to not just be there as a witness for prosecution, but to be part of the process. I have a right to reject the terms of the plea agreement because I do not find it fairly done, or it was some collusion between the prosecution and the accused person. So we need to do that education more, so that together the general public and the court will help to safeguard the process, so that the aims of this plea bargaining will be achieved. As
you spoke at the start, you were referring to Kenya, Nigeria. You know, I thought most of the references you were going to make would be from the state. You started with the state, where you also called to the bar there. And I was like, oh, so our next door people, they all have this.
They do.
Why did it take us this long?
Well, if you look at the fact that we had that provision as far back as when the Court Act was enacted, it really didn't take us. But this act is a very comprehensive act to, regulate plea bargain, not just for, let's say, the Office of the Special Prosecutor, the Office of the Special Prosecutor, or just under the Court Act, but to cover broadly all offenses.
But the 1993 provision is very limited.
Very, very limited. It talks about financial crime. If it causes
and it's
loss
to the state. It's
exactly.
not against somebody else.
Exactly. So we thought that, the way where the trajectory of criminal justice requires that we have this comprehensive law on plea bargaining for all offenses except those that are listed under Section 162R.
Right. And it's also refreshing to note that in the new Narcotics Control Commission Act 2020, we have also provided for plea bargaining.
Specifically for the couriers.
Okay.
The person who is the courier for the drug. And so you realize that is also specific. That came before Act 107. I was also very specific.
Prosecutor Act.
Yes, what you call the small fish within the chain supply in narcotics.
So we did Special Prosecutor Act and we provided plea bargain there, but of a general nature. And then we did narcotics.
For corruption-related offenses.
Yes, right. Then we did narcotics, and then we provided for a limited use.
For limited use. Now the plea bargain.
Now we have done what is all-encompassing.
It's all-encompassing, except those listed under Section 162R. And again, I told you for that, it was based on the stakeholder consultation that we did. I can hear some
producers talk, say, why? Why example all this in MEDA, all of this, why do you take them out?
Ghana, I told you that, again, let me also appreciate the U.S. Embassy. This work was done comprehensively with the assistance of the U.S. Embassy. Started at the time of the Criminal Justice Advisor, Mitchell Jackson. LADA, Law and Development Associates, were the consultant. We went through every region to get the inputs of the general public on this bill. Of course, the working group also included the judiciary and the Ghana Bar Association. And even though the research indicated that 99.8% of Ghanaians wanted this law to be passed, they do not want it to be wholly passed. There had to be that exception. And of course, I believe that as time goes on, and if Ghanaians feel that we have locked home up our abhorrence of some of these offenses, Ghanaians themselves may be willing to amend this, and then there may be no exceptions at all.
Thank you so very much. Dinah Asonaba Dapaah is a Deputy Attorney General and Minister for Justice. This has been the law. It's your legal rights. It's your health law. Once again, we can't thank you enough. Thank you.
You're welcome, Sam.
All right. All right, have a good afternoon. God willing, we come your way with another edition of the show, same time next week.